Information Station.
Welcome back. I'm Vincent Perryman and you're watching Legalese. Joining us on our show is Bill Jones of the Jones Law Firm. We are discussing family law. Bill, before the break we were talking about the how it's now an equation for child support, and you plug in the spouse's or ex-spouse's income.
That's right.
And it spits out a number. What happens as income changes, whether somebody loses their job in these hard economic times or somebody actually gets a pay increase?
Well, the answer to your question is that at that point they would come back in to our office or someone else's office and file a petition to modify. The law is, it's evolving. It moves with people, and it understands that life happens, that dads are going to lose their jobs, that dad may remarry and have 2 other children. What the law says is that if there's a material change in circumstance, that you're able to come in and ask the court to modify your child support. At that point, you plug in what your new income is. You plug in any other changes that may have occurred. If, for example, if one child is now 19 and has fallen off that calculation, then we would adjust it for that. The other thing is that you cannot willfully, though, underemploy yourself. In other words, if you were upset that your child support was high, you could not say, okay, I'm no longer going to be an attorney. I'm going to go in my garage and make wooden furniture and make $5,000 a year.
I might make more doing that.
The court would not allow you to do that. In that case, the court would say, okay, you have the potential to earn this much money, and they would impute your income. But if you can show that through no fault of your own, through these hard economic times, or maybe you've gotten a raise and the wife wants to come in, or the wife has won the lottery and the husband wants to come in. Any situation, any major life change, you can go in and modify it. But the key for the modification to be successful is there has to be a 15% change. So if it does not affect your child support, the new numbers, by 15%, then you're not going to get that modification. And that keeps little changes in pay from binding up and tying up the court's time.
Okay. Well, now with contested divorces, what are those grounds, and how big of a mess does that get to be?
That gets messy, or it can help matters. The nice thing about a complaint for divorce is that you're going to allege 2 grounds. One ground that you're going to allege is going to be irreconcilable differences, and the other is you're going to select one of the grounds that we have available to us in Tennessee. It's a fairly long list. There's the usual suspects that you would think would be there: adultery, habitual drug use, abandonment, failure to follow to the state of Tennessee. The catch-all that we use on there, if we don't have a solid ground like adultery or drug use, is going to be inappropriate marital conduct. So we supply ourselves with 2 grounds, and what that allows us to do is to jump back and forth between contested and uncontested, where if you want to go down that contested path, or you don't want to, but if you have to go down that contested path because you and your spouse can't agree on a marital dissolution agreement, well, then we can start you down that path. We'll set you up with things like preliminary hearings that will get you temporary alimony, temporary child support, temporary parenting plan. These are things that basically set you up for success, because the contested divorce process takes quite a bit longer. After we have those little hearings that are going to set you up, then we launch into discovery. And discovery is the longest and most expensive part of a contested divorce process. It's not like Perry Mason or the John Grisham novels where you put them on the stand and learn what you want to learn then. We try not to go into court and not know the answer to the questions that we're going to ask. And the discovery process that's how we get to that step. But if in that discovery process we find out something, maybe the other party might say, okay, that's enough, I'm done, and then we can segue in over into an uncontested divorce because we've supplied both of those grounds in our initial complaint. If that's unsuccessful, then we go to mediation. And mediation is where we both sit down with both you and your attorney, and your husband or wife and their attorney sit down with a mediator. And the mediator doesn't bang a gavel and say, this is what you're going to do, but he tries to facilitate an agreement. If that's unsuccessful, then we go to trial. But at any point prior to trial, we can hop over and write up an MDA and a permanent parenting plan. And that's important because you really want to try and settle one of these divorces. You don't want a judge, and certainly I don't think a judge wants to decide where your kids are going to be spending Christmas Eve for the next, until they turn 18. That's something that you and your spouse really need to try and decide upon yourself. And the law understands that, so they do as much as they can to try and give you opportunities and try and push you into settling. It's the same with property. I mean, judges really don't want to get in there and divide up your property and your assets and talk about toaster ovens, and those are things that you and your spouse should be able to decide on your own. The other thing to remember is if we are arguing over a TV set and toaster ovens, they make more. You're going to incur probably more attorney fees arguing about those things. You could go out and buy a whole new china set. So those are things that you probably shouldn't argue over.
Yeah, and I guess one thing to clarify for any viewers that don't understand what discovery is, that's just the process of requesting documents and basically deposing individuals, which would be sitting them in a room under oath and asking them questions. Right.
The way that we find out information is we send over admissions. And what that's going to do is that's going to limit what are we arguing about. If we think that your wife is having an affair or your husband is having an affair, and we send over an admission saying, please admit that you're having an affair, and they admit it, okay, that's one less thing that we've got to argue about. We've established our grounds. And there are other discovery tools that we have available.
All right. Well, we can discuss some more on discovery when we return from our break. We'll talk more with Bill Jones about family law. Please stay with us.